Hi guys, I hope you can hear me. I'm filming this in my hotel room. We just wrapped up court at around 4:45. If you can hear me, please leave a comment because I'm filming this using my computer microphone. I didn't bring a microphone. So I guess I'll get started. We're just in court, as I said. I'm back in my hotel room now. I'm sure everyone who's joining this stream knows who I am. I'm Christine Van Gyn with the Canadian Constitution Foundation. I'm back in my hotel room in Ottawa after a really long day in court. For those of you tuning in, I'm sure you probably know, the federal court is hearing our challenge to the Trudeau government's use of the Emergencies Act in response to the 2022 Freedom Convoy, which actually happened just about right around where my hotel is here in Ottawa. The case is being heard by Justice Mosley of the federal court in Ottawa, but for space reasons, the hearing is actually taking place in a room at the Supreme Court of Canada, which does have federal court hearing rooms inside it. The courtrooms are really nice. They have these super high ceilings. The courtrooms have, on the ceiling, there are these coffered ceilings with rosette detailings. There's this plush red carpeting. There's beautiful ornate wood paneling. It's one of the nicest hearing rooms that I've been in. But what really matters is what's happening inside. So the case was brought by us, the Canadian Constitution Foundation, and separate cases were also brought by a group called the Canadian Civil Liberties Association and another organization called Canadian Frontline Nurses. And there's also a group of individuals who are impacted who also brought a case. But we've all brought the case against the federal government. So arguing on the other side is a lawyer for the Attorney General. And the government of Alberta is also intervening in the case as well. So we have all these different cases, these 4 cases. They're all separate, but they are being heard together. So the way the days are working is each counsel for the applicants gets 2 hours, and we are going in order in which the cases were filed with the court. So Frontline Nurses was first, then the Canadian Civil Liberties Association. And we didn't actually get to make any submissions today because a lot of time was used up by these kind of dumb preliminary matters. And I'll tell you a little bit about them. It was stuff that the government wanted addressed as preliminary motions. But I'll tell you a little bit about that. But in the long story short is that we are going to be going tomorrow. So remember, before I give you the summary of what happened today, I want you to remember that nothing here is a verbatim quote. It is not for attribution to any of the lawyers, the government lawyers, or to the judge. This is all just my best recollection based on my notes, and it's a description of the hearing. It's not necessarily my opinion of the hearing unless I tell you explicitly that it's my opinion. So let's get to what happened. We had these preliminary matters, and they related to 2 motions that were filed by the Attorney General last year, I guess, April last year. And the motions are about mootness and standing. Basically, the Attorney General was arguing that the case shouldn't be heard. Shock, the government doesn't want to have the case heard because they said the emergency has been revoked. And they're arguing that the people who brought the case aren't in a position to bring it, with the exception of 2 individuals who actually did have their bank accounts frozen. So they can't really fight the standing of those people. So Justice Mosley said that he did not want to spend all day on these preliminary matters. And in fact, the CCF and the CCLA were not going to make any oral arguments about it at all, and we didn't. I think that this is because the government's position is really weak. But unfortunately, the court did spend the first 2 hours of the hearing dealing with mootness and standing, and the lawyer for some of the individuals, as well as the lawyer for Frontline Nurses, did give a little bit of an oral response to those lengthy submissions by the Attorney General. So I'll go over what they said on mootness. Basically, there's this 2-step analysis to determine if a case is moot and if the court should hear it. The court asks, is there a live controversy? And then if not, if the court should exercise their discretion to hear it anyway. And the Attorney General took the court through a number of cases about mootness that have happened in the past year, in particular, where the court exercised discretion not to hear the cases, and shock, a lot of those related to vaccine mandate issues or border COVID restriction issues. The Attorney General said that the similarity between all these cases that they were referencing is that the absence of a live controversy would have had no practical or meaningful effect on the parties. The AG, as I said, brought up a case about vaccine mandates that wasn't heard because of mootness, basically just ran down this long list of cases. They said the clear theme is where an issue will not affect the rights of parties before the courts. They said the court should not exercise the discretion to give an opinion about it. In this case, the Attorney General said the emergency was revoked over a year ago, so a declaration would have no practical utility. Now, Justice Mosley interrupted here to say that the applicants are arguing that if the court doesn't hear this, then the decision of the government to invoke an emergency would be evasive of review. That is exactly what we have argued in our written response to this motion by the government. The government, the Attorney General, responded to Justice Mosley's question about this argument on evasiveness by saying it's based on speculation. He said evasiveness applies in different situations where there are events repeatedly superseded by other events. And he gave some examples, like a case on egg quotas in Saskatchewan, a case on immigration detention reviews, where each review makes the previous review moot. And he said, the Attorney General said, given the extreme rarity of the Emergencies Act's use, we have no idea what a subsequent invocation will look like or when it will occur or what the circumstances around it might be like. He argued it's highly unlikely that the circumstances would mirror the 2022 circumstances. Justice Mosley asked if the Attorney General is suggesting that the Emergencies Act would have been ripe for a judicial review during that brief period when it was invoked and enforced. That could there be a judicial review in as short as 24 or 48 hours if it was only invoked for that short a period? During that period, could an affected party bring an application for judicial review and have it heard? The answer is kind of in the question. It took us a year to get here, so no, it's very unlikely it's almost impossible that you would have a judicial review heard within 24 hours. So the AG conceded this. He said perhaps not on a 24-hour period. And Justice Mosley said, well, here it was 9 days. During that period, that 9-day period where the emergency was invoked, how much evidence was available for any person affected by the invocation of the act to bring a judicial review? And the Attorney General said, well, they did. The parties were before the court very quickly. But this, as Justice Mosley pointed out, this was on a stay motion. So it's a little disingenuous of the AG here. The AG is getting into a really tight spot here. So, when lawyers are in front of a judge and they're in a tough spot, they will often say, oh, well, this is a hypothetical. So that's exactly what the Attorney General said. He said, we're engaging in a hypothetical about when this might occur. Mosley didn't seem to be buying it. He said, no, we have real facts here. A 9-day invocation and the regulations created under the Emergencies Act. Putting aside effectiveness, effectiveness of using the act, people were affected. Some 200 charges under other statutes were laid. What evidence would have been available for an affected party who wanted to bring a JR, a judicial review? And the Attorney General replied there would have been some minimal evidence for them to have brought one. Mosley came back saying, well, what evidence? The Section 58 explanation for invoking the emergency came after. So here the the Attorney General seemed to pivot and said, the question for a court is actually what would be the utility in a decision in a case like this when the emergency has now been revoked. So here's where Justice Mosley gets to, I think, what the crux of the matter is on mootness. He said, if a case like this one couldn't be heard, when could one ever be heard? And the Attorney General evaded the question, basically. He said that emergencies are temporary by nature. This is all hypothetical. In the future, an emergency could be heard for longer than 9 days. And that would be the case where the matter would be brought before the court. He said that for this court to pronounce on constitutional matter and give a declaration in the abstract, he said it could tie the hand of a future court. And this court, Mosley's court, should not allow for the possibility of a future longer emergency that by engaging in analysis based on facts no longer in effect. I don't think that this was particularly effective. So the Attorney General then moved on to the second part of the test on mootness, whether, even though there's no live controversy, whether the court should still exercise discretion, although, he kind of was already giving submissions on that. So when determining the answer to that, whether the court should exercise discretion, the court asks 3 questions. Is there an adversarial conflict? Is this a good use of judicial resources? And is this the proper role of the court? So the Attorney General said there's no adversarial conflict here because the Emergencies Act is no longer in effect, and that the court should not hear a moot matter where a decision would have no collateral consequences or legal impact on the applicant's rights. On the efficient use of court resources, the Attorney General argued where a decision won't have a practical effect on the party's rights, it's lost consequences, and this court shouldn't use its scarce resources on that. The Attorney General said that this is the guiding principle that court should think about and should guide this court. And the court could not, he also said the court could not deliver any remedy that would affect the party's rights, and that seeking declaratory relief, which is a declaration that rights were violated or that the standard of the act was not met, he said that can't sustain an otherwise moot application. He said it's not the role of the court to decide purely academic or abstract questions when there's no useful function served by declaratory relief, citing a case with Rebel News. He said, the Attorney General said that unnecessary constitutional pronouncements should be avoided and that the law on this is settled and it's not about being evasive of review. The Attorney General then turns to the second question, which is about the use of judicial resources. And he said the court shouldn't use their scarce resources just because it might be helpful to create case law, even if, and he said that's the case even if significant resources have already been expended up until this point. Because just as Mosley pointed out, it's taken a year to get here. We've already used a lot of resources. Why don't we just proceed with these hearings, with these 3 days of hearings, when we've spent months on preliminary motions? So the third part of the test on whether the court should exercise their discretion and hear a case, even though there's no live conflict, is about the proper role of the court. And the Attorney General argued that this is a policy-based dispute. The use of the Emergencies Act is about policy and about the appropriateness of invoking the Emergencies Act, and that a court needs to be sensitive to its role and not intrude into the legislative or executive branch. Mosley interjected here asking, isn't this more than a policy dispute? It's about the lawfulness of the invocation of the act, and in the context where it arose, this is a legal controversy, isn't it? And the Attorney General conceded, yes, there is a legal question, but he said there's no live controversy. Mosley pushed back, asking if the AG's point is that there's no merit in deciding the matter because the emergency was revoked. Is there no benefit, no point in clarifying the law? And the AG said, yeah, that's right. The court shouldn't hear it. There is no point. The court shouldn't exercise its discretion for abstract pronouncements without a factual foundation. Though, of course, we did have a factual foundation. It seemed like to me like Justice Mosley wasn't buying it. He pushed back saying, even though this law has never been interpreted, we shouldn't interpret it now. And the AG again said, yes, because we don't know what a future invocation might look like. The court shouldn't make these pronouncements when we don't know what the future may bring. Mosley also asked, is the question of the Section 2 of the CCLA Act definition and how it should be applied, is that an abstract question? Remember, this is a part of the core of the dispute over the merits of the case. The legislation says one thing, that this is the threshold for invoking an emergency, a threat to the security of Canada as defined in the CCLA Act. And the government has this radical and novel interpretation that seems to go contrary to the words of the statute. The AG replied by again saying, well, we don't know what the future will bring. Mosley said that is not his question, We have the wording of the statute here, chosen by the drafters of the statute, taken from one piece of legislation, the CCLA Act, and brought into the Emergencies Act. Is there not some value in determining how that should be interpreted? And the AG again said, nope, there's no value. We don't know how it might apply in the future, so a court should defer to a future scenario and how the facts of that scenario might apply. I don't think that this is going very well for the AG, by the way, my opinion. The Attorney General then moves to the proper role of the court. That's the third question the court asks itself on whether they should use their discretion to hear maybe otherwise moot case. The Attorney General said that the Public Order Emergency Commission already did an inquiry based on a more extensive evidentiary record, and they created a report. He said that a joint committee of Parliament is reviewing the House of reviewing this and has voted on it. The House of Commons voted on the invocation. And he said all of these factors should give the court pause to reflect on their role given these other processes that have concluded or that were in process. He said that the legislative history might be relevant, but it isn't determinative in the way that we at the CCLA, CCF and CCLA are suggesting. So that wrapped up the beginning of the day on mootness. The Attorney General also made a number of submissions on standing. I won't go through them because I think these arguments were even stupider than his mootness arguments. Basically, the Attorney General is trying to get everyone kicked out, saying none of us have standing to be there except for those two individuals who they could stay because they actually had their accounts frozen. But he said, we at the CCF don't raise an issue different from the parties, that there's no judicial issue because the case is moot. And if we wanted to be there, we should have sought to intervene instead. We shouldn't be a public interest litigant. So Justice Mosley, I don't think there's much strength to those arguments, and we've responded in writing. Justice Mosley hasn't given a decision. He reserved on both standing and on mootness. I don't think it went well, but unfortunately, the government did get to use up more than 2 hours of valuable time. So we finally then got to move on to the merits of the case. And as I said, it started with arguments from Canadian Frontline nurses. The lawyer representing that organization is named David Cowling, and he's a management side employment lawyer from Toronto. Cowling for Frontline nurses started by describing his clients and their passion about medical choice and their concerns over the direction Canada was headed during the pandemic. Justice Mosley basically stopped him immediately and said he doesn't want or need a speech on what the client here believes. I don't think anyone should take that as a bad sign. There really is not a purpose. That really is not the purpose for this hearing. This hearing has nothing to do with the purpose of the protests. It has to do with the purpose of the Emergencies Act and the legal thresholds in it. It has nothing to do with vaccines, and we don't want to muddy the waters. Judges are capable of separating their feelings about the purpose of the protests and the law related to the Emergencies Act. And I have no doubt that Justice Mosley is able to do that. So spending a lot of time making political points is not helpful to the court. But counsel for the Frontline nurses still did make a number of political points. He said Canada had some of the world's most draconian policies with respect to vaccination. I think that's probably true. We were pretty bad. Not as bad as perhaps Australia and China, but Canada was pretty bad. He said that people in Canada couldn't see their dying relatives in other parts of the country or leave the country. Mosley interjected to say, I'm not here to judge the COVID policies. I'm here to judge the Emergencies Act. Counsel for Frontline nurses said, what's important, why he's bringing this up, is because the context of the protests and how they arose matters, and that there was a real world experience. People felt their freedoms were being eroded, and they wanted to express that. He said that governments and the private sector had imposed mandates, and tens of thousands of Canadians had lost their jobs. Mosley asked, is there evidence in your record to support that number, the 10,000? Cowling said no, the court could take judicial notice, to which Justice Mosley said no. Again, here I do agree with Justice Mosley. You can't just make an assertion and ask the court to take judicial notice, you need to back up your claims with evidence in your record. Judicial notice is for things like gravity. It's something that is so plainly obvious that you don't need to bring evidence because it's like a common sense type of thing. Like gravity exists. Canada gets colder in the winter. And I actually think part of the problem that we have right now is that courts are taking judicial notice too liberally. Some of you might know of some cases where courts took judicial notice about the safety and effectiveness of vaccines. And really, we shouldn't be encouraging courts to take judicial notice so freely like that. We should expect evidence and argument. So I have no problem with Justice Mosley saying, I will not take judicial notice of that. If you want to make an argument about how many people lost their jobs, even though in my view it's probably not relevant to the invocation of the Emergencies Act, you need to put that into the record. So Cowling for the frontline nurses then turned to statements by the Prime Minister where he called those who opposed mandates misogynists and racists, etc. And Cowling said that this was all rhetoric coming from a Prime Minister who repeatedly wore blackface. Now, while this definitely resonates with me politically, it's not relevant at all for the hearing. And Mosley interrupted saying, I am not interested in these political statements. If that's what you're going to do here, you may as well sit down. And things got a little rough because Cowling continued to talk about the 2 years of COVID devastation, followed by the trucking mandate, which is when the convoy began. And he said people who had not been able to travel finally had a voice. They were not a fringe minority. And this gave rise to a worldwide movement. And Mosley interrupted to say that you're belaboring the point, move on, and that he was actually starting to regret the decision to have Cowling heard, that this is of no assistance to the court. And Cowling, though, continued to make points about the protest context and the politics surrounding the protests, and Mosley kept stopping him, saying, I'm here to consider whether invoking the Emergencies Act was reasonable and lawful, and you've pushed the context too much, get on to the law. So finally, that's what he did, which is a good thing. We are here to talk about the law, not the politics. We can talk about the politics as much as we want in other situations, but not with the limited time that the court has to consider the law. We need to consider, be very careful with our time and make it very clear what we're arguing. Cowling did go on to do this, so that's good. Cowling said that Cabinet, with respect to the Emergencies Act, does not just have free rein in interpreting this statute or any statute. Their decision to proclaim an emergency is constrained by the purposes of the Act, and that Cabinet is required to comply with the definitions in the Act before complaining a public order emergency as is defined in that Act. He explained that a public order emergency has two criteria: threat to the security of Canada, and that threat needs to be so serious as to be a national emergency. And of course, as we've all talked about so many times, a threat to the security of Canada has the meaning assigned to it in Section 2 of the CCLA Act. Cowling said for frontline nurses that there are a number of different potential threats that the Act considers, like espionage, sabotage. And he said that the Attorney General has suggested activities in the Freedom Convoy were captured, including this notion of serious violence directed at an ideological goal. He said that this is not made out, though. While the protest was designed to achieve a political objective, there was no, it was not through a threat of serious violence or the use of violence against people. There was a political basis for the protest, but there was no threat or act or use of serious violence. Cowling then turned to the definition of threat to the security of Canada, which, as we all know, incorporates that CCIS definition. And he said, what CCIS thinks matters and speaks to the reasonableness of Cabinet deciding there was a threat. Now, recall from the Public Order Emergency Commission, we learned that CCIS found, the CCIS director, Michael Vigneault, said that the protest did not constitute a threat to the security of Canada under their statute and never constituted such a threat. Vigneault confirmed that he expressed his views to the Incident Response Group, which is a group of Cabinet, and they did not consider what happened in Ottawa or elsewhere as a threat to the security of Canada. Cowling said that what happened here was the creation in the imagination of government of a fantasy version of the protesters. He said they were not far right groups with foreign money trying to overthrow the government in some January 6th fashion. While we can disagree with their perspectives or not, they were not violent insurrectionists or a threat to the security of Canada. There were no overt acts of violence, although perhaps there was annoyance to the residents of Ottawa. He said this was by and large a peaceful demonstration. While there perhaps were crimes of mischief or nuisance, there were no crimes that were threats to the security of Canada. Cowling then spoke about this memorandum of understanding that was circulated by some people within the convoy. He brought it up because the government, the Attorney General, is relying on it as some kind of evidence that there was a plan for violent overthrow of the government. Cowling said, we've got this MOU, and certainly it seems to call for a different type of government that's very dissimilar to the type we have now. And it wasn't, in fact, supported by frontline nurses or by many people in the convoy. It was just a document that some people were circulating. But moreover, just because it calls for a different form of government doesn't mean it's calling for a violent insurrection. He compared the MOU to calls to end the monarchy. That's a call for fundamental change, but that doesn't mean we should forbid the debate in our country, as long as there isn't an attempt to achieve that goal through serious violence or calls for serious violence. Mosley then interjected to say he thinks the only thing that the MOU demonstrates is that we failed to educate our public about our Constitution and system of government. And yes, I certainly agree. It is evidence of that, sadly. But if you want to learn more about our Constitution, you can go to the ccf.ca/learn, and we have a whole free course that you can take on learning about our Constitution and our Charter and our fundamental freedoms. So that is one thing that we're trying to do to rectify that perhaps public education deficit. Then we had our lunch break. I ate a really nice salad at this place called the Mad Radish. If you're in Ottawa, I'd recommend it. It was really good. And then we came back, and the frontline nurses, Cowling, returned to talk about the tactics of protesters, including how they brought children to the protests, they blocked streets and were noisy, but that none of this arose to a threat to the security of Canada. He also addressed how the government is arguing that our ideologically motivated violent actors may be motivated by the protests, but there's no identification of who these people are or what they might be planning. That jerry cans of gas, honking, and waving flags is not a serious threat of violence. There needs to be an actual threat of serious violence. Just imagine the harm to the democratic right to protest if that were the test. Yet that seems to be the reason that the Privy Council office supported the invocation of the Emergencies Act. Expanding on that point, Cowling pulls a quote from the Prime Minister during the Public Order Emergency Commission, where Trudeau said, if something terrible had happened, how would he have felt? But this isn't the threshold. There needs to be a credible threat or actual violence. And remember, CSIS did not believe that such threats or violence existed. To really bring that point home, Cowling brought up a now sort of notorious memo from the clerk of the Privy Council office to the Prime Minister. This is the memo that talks about whether the Emergencies Act could have been invoked, and the document relies on the level of disturbance and public unrest and how it was being felt beyond Canadian borders. And the clerk said this may give momentum to the movement and may cause other harms to, quote, social cohesion, national unity, and Canada's international reputation. Just give me a second. I have to drink a glass of water. So Cowling then points out, I think correctly in my view, that those things are all political concerns: social cohesion, national unity, international reputation. They're not concerns about threats of violence or actual serious violence. It's an improper motive for the invocation of the Emergencies Act. Yet the Privy Council memo says that these were concerns that were within the scope of threats to the security of Canada, although it famously admits that this interpretation may be vulnerable to challenge. Well, indeed, here we are challenging it. Cowling for the Frontline nurses said that this Privy Council office memo reveals the true intention for invoking the act. It's about social cohesion, reputation, and national unity. He said that the convoy, in the convoy, there were no serious injuries, just this vague MOU. CISA saying no threats of violence or serious violence, but yet we still have the invocation of the act. This gave the government a new power that we'd never seen before, which he called a hallmark of a totalitarian regime, and that's the ability to freeze protesters' bank accounts or the accounts of anyone who supports them, freeze them out of their financial markets and out of their own bank accounts without any due process. He calls this crass politics and not about any emergency. On the topic of freezing accounts, he says that the Attorney General has said only people who participated were targeted, not people who weren't participating in the protest but were maybe supporting it. But the problem is the order was broad. It did empower the freezing of accounts for the supporters of the protesters. And Justice Minister Lametti was asked in an interview if donors should be worried. And he answered, if you're a member of a pro-Trump movement who has donated hundreds or thousands of dollars to this, you should be worried. Now, here Cowling actually pointed out the irony, which had not occurred to me before, that it was actually the Trump administration that developed the vaccines through Project Warp Speed. But, God help you if you are the supporter of a pro-Trump movement, which happened at the time to be the sitting president of the United States. So Cowling hammered home the point that anyone who did donate ought to be worried, and that the government actually wanted to send that message to their political opponents, and that message worked. People who anonymously donated had the donation list hacked. There was stigma associated with donating because the government was equating donating with being a part of a threat to the security of Canada. And some people who donated were actually disciplined by their employers. The government cast this very wide net. The financial measures, Cowling said, put a duty on financial institutions to cease doing business with a designated person. This was these people who the government designated who were participating in the protest. And he said it was an unclear protest. The Emergencies Act regulations could apply to anyone who in any way supports any person who participated in one of those prohibited gatherings. And he said that the insidious message of the government was clear: don't support the government's political enemies. Cowling then turned to another, what he called precondition to invoking the Emergencies Act, and the word effective with respect to existing law. He said that the Emergencies Act has this precondition of a last resort clause. As he said, the question is whether existing statutes can be used to address an emergency, and this makes this a requirement of last resort. He then goes through some other statutes that could have been used to deal with the protests, like the criminal code or obtaining injunctions. And he said, look, the criminal code was used here in enforcement, and there was no injunction that was sought here in Ottawa by the government. It was sought by the provinces for the border crossings in Ontario. It was a tool that the federal government never attempted before, what he called the sledgehammer of all sledgehammers, the Emergencies Act. And Cowling said that this failure to get or even seek out an injunction, he said, is fatal to the government's position, since it shows that other laws of Canada, including the common law, could have been used but were not. Cowling argued that the measures also that were created under the statute, that was the gathering prohibition and the freezing of accounts, he said that these measures were overbroad and disproportionate and a breach of not just the Charter, but of the Bill of Rights. The Bill of Rights argument is an interesting one. We don't actually often hear about Bill of Rights arguments. So he said that when it comes to freezing accounts, there was simply no process. There wasn't even a minimal amount of procedural fairness. There was no hearing, no information about how you became a designated person or how you could challenge your status as a designated person. He said the manner in which the order for freezing accounts was implemented went even beyond what was contemplated in the order itself. The order was designed to breach privacy expectations, he said. But he said every record and every interaction with police was shared with financial institutions for designated people. What they did went beyond. In doing this, he said this went beyond even the order. It was a breach of the Bill of Rights to deprive Canadians of their property with no due process. And here there was no process at all. So Cowling concluded, he's the lawyer for Frontline nurses, he concluded by saying, we are looking to the courts to provide a check on the government's abuse of power and to declare the invocation of the Emergencies Act ultra vires. Then we took a brief recess for the lawyer for the Canadian Civil Liberties Association to get ready, and then she came out. The lawyer for the CCLA, the Canadian Civil Liberties Association, is Eva Krajewska. She's a regulatory lawyer in Toronto with the firm Head and Hutchinson. You may know that firm. Its principal is a very famous Canadian criminal lawyer named Marie Henin. Eva is fantastic, and she did a really amazing job. She split her submissions with her co-counsel. She addressed the question of whether the governor and the cabinet's invocation of the legal threshold to invoke was reasonable, and her co-counsel addressed the charter. The first issue that Eva for the CCLA addressed is reasonableness and what it means in this context. The Attorney General said that because of the nature of the decision maker in this case, which is the governor and council, or we call it the cabinet, the AG says because it's the cabinet making the choice, a significant amount of deference is owed. Now, Eva explained that the CCLA strongly disagrees with this submission. She said that, the Attorney General is saying that it's a policy-making role that the cabinet is engaged in, and this is what grants them deference. But just because the cabinet is at the apex of decision-making doesn't stand for the proposition that deference is owed. It's the statutory language and the context that matter in determining if the decision was reasonable. And in the CCLA's view, it's very important in the context here. It can't just be that, because the decision maker is cabinet, they get deference automatically. That would actually have massive consequences on parliamentary democracy and the rule of law. Eva argued that the decision maker is constrained not by who they are, but by the parliamentary language and by statutory intent and by context. She then systematically went through the case law around reasonableness. After all, what we're asking is, was Cabinet's decision to invoke the Emergencies Act reasonable? Now, I won't take you through all that case law other than to mention that she cites a case by Justice Stratus of the Federal Court of Appeal, which considered the different types of deference that can be owed to a decision maker and stresses that it is not the nature of the decision maker, but the words of the statute that matter. CCLA's point is that it's not the decision maker's identity that determines the level of deference for reasonableness. It's the statutory language, and that this is consistent with standard of review case law, specifically a famous case called Vavilov that governs this area of law. She said that the specific wording of the legislation is important in determining the level of deference, and we spend a lot of time on this because we're asking if the government's interpretation of the Emergencies Act, if that interpretation was reasonable. And the legislation in this case has a very different wording from the cases that she just took us through, which had a more policy-oriented analysis by cabinet. This case didn't have this specific statutory language that said cabinet can consider all of these policy topics. In this case, it just says the words of the statute refer only to threats to the security of Canada and the CSIS definition. Next, Eva for the Canadian Civil Liberties Association moved on to the legal test for invoking the Emergencies Act. The court pulled up the text of the legislation, which defines national emergency, and says the two main pillars for invocation are threats to the security of Canada and national emergency. And this is important because there are 4 types of emergencies in the legislation. It's not just about public order emergencies. There's other types like public welfare emergencies, and public order emergency is the only one that uses the term threats to the security of Canada. The Attorney General's argument, as explained by the CCLA, is that threat to the security of Canada cannot be interpreted just by CSIS, just by the CSIS Act, because there is a different context. The Attorney General says the determination by CSIS isn't conclusive because there are different legislative purposes and contexts between the CSIS Act and the Emergencies Act. But the CCLA says, let's step back and look at where the definition of threats to security of Canada came from. And there were some commissions arising out of the excesses of the government related to the War Measures Act that actually led to the development of this definition and this legislation. So Eva then went through the legislative history and pulled quotes from those commissions that worked on reining in those excesses. And there's a foundation for this phrase, threats to the security of Canada, coming from the Macdonald Commission and the Pitfield report that came out of these excesses following the War Measures Act. And she said that legislative histories are helpful for determining legislative intent, and they're useful for the courts for interpretation. And she said that the Pitfield report discusses the definition of threats to the security of Canada, and it specifically relates in that report to political violence. So when we look at the entire scheme of the Emergencies Act, we have these 4 different types of emergencies, but only public order emergencies have threat to the security of Canada as part of the definition. So that should matter for the court's interpretation, for the weight that we place on that definition. That definition matters. It's not just subject to the whims of cabinet. So Eva for the CCLA then turned to the Attorney General's argument that the context of the CSIS Act and the Emergencies Act are different. She said the CCLA disagrees that the context creates a different definitional threshold. And Mosley asked, do you think that the contexts are different? Well, yes, of course, the contexts are different, but that doesn't change the statutory interpretation. Eva says in both acts, the consequence of the threshold being met is that a government entity will create rules or they will undertake activities that have charter consequences that violate the rights of the people who are impacted. With respect to the CSIS Act, it affects individuals who are put under surveillance or have an investigation started regarding them. And in the Emergencies Act context, it's going to not just have consequences on specific individuals or on specific terrorist designated groups, but potentially all of Canada as a whole. Now here, Eva and Justice Mosley got into a bit of a back and forth on the CSIS Act. He said that, when the Emergencies Act was adopted, Parliament had just adopted the CSIS Act. It had actually never been interpreted before. The big difference is that CSIS uses it, and they use it all the time for conducting investigations. It gives them the scope for surveillance and for investigations, but the threshold to get there, to determine if there's a threat to the security of Canada and they can start surveillance or an investigation, he said under the CSIS Act, he knows a lot about the CSIS Act. He has worked on this on national security issues a lot, Justice Mosley. He said the threshold for that for CSIS is low. If CSIS wants to go beyond surveillance or starting an investigation, they have to come to the courts, and it takes months. Here, in the context of the convoy, he said we had a rapidly evolving situation nationally, a problem in Ottawa that was beyond police capacity, and the government was looking at what they can do. And he said he can tell you that affidavits to support CSIS warrants are extensive, with hundreds of pages of supporting material, and take months to get heard. He said in this case, this use of national threats to the security of Canada is a sui generis interpretation. It has never been done before. The definition in this case has to be applied, and we're the first ones to apply it. And the CSIS director said, the definition doesn't work for their purposes. They didn't think the convoy had a national security threat. But he didn't have, but Vigneault of CCIS said he didn't have a problem with it being applied in the context of the Emergencies Act. So he asked Eva for the Canadian Civil Liberties Association, how do you respond to all of that? Before she could answer, Mosley added, he has a problem that he knows a great deal about how the CCIS Act works. And there have been a lot of problems with CCIS assessments over the years. And when he hears the arguments that you have to rely on a CCIS assessment as a key factor, he says, well, gee, I don't know about that. It still comes down to statutory interpretation and how to apply it in this context. But this is a challenge for him. Eva said that for the CCLA, Eva for the CCLA said, yes, Parliament used an untested definition when they incorporated it into the Emergencies Act. To her mind, though, she said what Parliament was creating was a requirement of a threat of international or domestic terrorism of such a scale it can't be dealt with under any other laws of Canada. The issue is what is the different context. The issue with what is the different context is that we don't know what the different threshold is. They can't be suggesting that for the Emergencies Act, the threshold is lower. And in fact, the Prime Minister agreed with that when he was cross-examined by Eva at the Public Order Emergency Commission. He said, no, the threshold is not lower. She said the threshold shouldn't be relaxed. If the threshold is one thing for individuals or specific groups, it can't be lower for the entire country. Mosley seemed to confirm what she meant. He said, not lower than. And she said, I might even say higher. I might even say that if you're going to apply this to the entire country, it should be higher. She said Parliament didn't have to add the CCIS definition to the legislation, but they did. And that is really difficult for the court and for Cabinet to overcome. And through all these years, Parliament never changed the definition. And both statutes have at their core, at their purpose, at their intent, this notion of safeguarding national security. The distinction between the two pieces of legislation is the actual powers that are granted. So Eva said, for the CCLA, if Cabinet doesn't have the director of CCIS saying the definition is met, they have to point to something else, something that was persuasive or of a similar nature. And we just don't have that here. It's not in the promulgation of the invocation. It's not in the Section 58 explanation that was provided to Parliament. We have no one explaining the difference. Nothing is explaining what was akin to threats of serious violence if the CCIS definition isn't what the threshold is. If you're going to depart, she says, from that statutory definition that Parliament constrains you with, you need to justify it, especially in the context of the Emergencies Act, where transparency and accountability are so critical. If Cabinet is going to say we don't have to meet the CCIS definition, they need a justification for why a different contextual definition is met. And the lack of justification here creates a reasonableness problem under the Vavilov framework, which is that standard of review framework for reasonableness. So the CCLA then turns to what the Attorney General has said was a threat to the security of Canada. One of the things they rely on and give great attention to are these weapons that were found in Coots. They call it front and center. And Eva says the problem with relying entirely or just even significantly on Coots is that it's not clear how Coots was at this level of significance. Because if it was so dangerous, then wouldn't CCIS have said that their threshold was met? The problem is that Coots was also dealt with by the RCMP. The seizure of weapons was under a search warrant under ordinary laws of Canada. So what is so unique or distinct about that? The CCLA, Eva for the CCLA, then adds that the Attorney General's argument on this memorandum of understanding that it was some type of incitement to an insurrection, she said that's insufficient. She said the MOU is an indictment of our civics problem, which I agree with. But if it was such a threat, it would have been identified by CCIS. Justice Mosley asks, do you exclude the possibility that CCIS was aware of the MOU? Like, what if CCIS didn't even know about it? And Eva responded that she'd be very worried if CSIS wasn't aware, because this MOU was all over the news all the time, and it was actually cited in the Section 58 explanation. So it seems pretty safe to assume, at least, that CSIS was aware. Eva then goes on to say that the other parts of the Section 58 explanation, that is this explanation to Parliament about why the Emergencies Act was invoked, that it talks about ideologically motivated violent extremism. And to her mind, that's within the CSIS wheelhouse. They're able to deal with those sorts of threats. Yet they did not think it rose to the level of threats to the security of Canada. So it's difficult to understand how those same facts and examples can be looked at by Cabinet and met, but CSIS, with all its expertise in intelligence and being able to distinguish between threats, said no threat here. Eva then considered how the Section 58 explanation spends a lot of time dealing with economic impacts of border blockades. She said the Attorney General doesn't justify the use of the Emergencies Act on the basis of these economic concerns, and that they're correct not to rely on it, but because they certainly don't meet the definition of a threat. And Parliament made a choice not to include economic disturbance as part of a public order emergency. And they actually did consider it for things like natural disasters. So we need to, she said, be mindful of the importance of dissent, of things like strikes in particular, because they are going to cause economic harm. And just because they do that, we don't say that strikes are violent. And we should not be invoking the Emergencies Act to quell dissent just because that dissent can cause economic hardship. Economic hardship is not a part of the threshold for threat to security of Canada, and she just wants to make that point extremely clear. She then pulls up that memo from Privy Council, that same memo that Cowling took us to, which was drafted by the clerk of the Privy Council to the Prime Minister on the question of whether or not to invoke the Emergencies Act, and summarizing all the inputs so that the Prime Minister could make a decision. The clerk of the Privy Council summarized the test for invocation in the memo and acknowledged that the Ambassador Bridge was cleared, but writes that the situation nationally was uncertain and volatile. And as we discussed, it outlined threats to social cohesion, national unity, and international reputation. Eva says that in a democracy where governments enact laws, there just may be unrest and opposition to government policies. We saw that recently in Israel with proposed reforms to the judiciary there. That is legitimate. If Cabinet is going to depart, though, from what is the more traditional or apparent definition in the Emergencies Act of what is a threat to the security of Canada, which is the CSIS definition, she said there needs to be something there to justify it. What is the difference here? What is the different context? She said the existence of public unrest over public health measures is not of a quality that should be accepted as justification for invoking the Act. The reasonable way to interpret the Emergencies Act is to say you need to look at threats to the security of Canada under CSIS, and if you're going to depart from that, you need to give specific justification. Public order emergencies you need to also show that it's something that existing law is not enough to deal with. So Eva says the Attorney General doesn't offer this something else. And she said, look, to be fair to Cabinet, they need to know what this threshold is too. We need to clarify the law here. Eva then turns to the second part of the test for public order emergency, that is this question of whether or not the situation cannot be effectively dealt with by any other law of Canada or other provinces or territories. And she says there's a lack of clarity by the Attorney General about why this situation could not be dealt with by other laws. You know, the borders were cleared. There's no indication of what additional laws or resources were actually needed. And the Section 58 explanation, it was provided to Parliament, mentioned situations that were all dealt with by police under ordinary powers. There's no identification about what is missing, although she says there's a lot of discussion, especially at the Public Order Emergency Commission, about tow trucks, though she says in her mind, tow trucks are a rather small point, not a reason to invoke an emergency legislation. Now, with respect to Ottawa, Eva says the protesters did become intractable. They were entrenched there, but this was more tied to an absence of police resources. It's not as if the Emergencies Act gave more resources. So that was it for Eva. And in the remaining time of the day, the Canadian Civil Liberties second lawyer made submissions about the charter. Unlike administrative law grounds for review, like the review of the invocation of the Act, which requires a reasonableness assessment, the orders under the Emergencies Act are charter questions and are reviewable on a different standard, higher standard called correctness. Now, these submissions by the CCLA second lawyer needed to be pretty condensed because we only had about a half an hour left in the day. The first submission was that the orders had restrictions on the orders that restricted assemblies violated Section 2B assembly and 2B expression and 2C assembly rights. The second submission was on Section 7, life, liberty, and security of person, which was engaged because the prohibitions on assemblies came with a term of imprisonment, and that prohibition was overbroad. That prohibition was overbroad for a number of reasons, including because it prohibited all disruptive protests everywhere. It didn't just apply to violent protests. It could, for example, apply to a logging protest in British Columbia if it blocked a road. The third submission from the CCLA was on privacy rights in Section 8 of the Charter and the financial measures. And the last submissions were on Section 1 justification. So I won't go too much into detail because these submissions were really quick on these charter arguments. But basically, they closed their arguments by saying that the charter demands more than just identifying a specific problem. It actually requires evidence to show why infringements are justified. So that wrapped up the first day. We heard a bit from the Attorney General. We heard from the Frontline nurses. We heard from the Canadian Civil Liberties Association. I want to know if you guys watched the live stream. If you register with the court, you can watch tomorrow and on Wednesday. I put a link to in the description about where to register. And if you can't watch it, you can follow me on Twitter. My handle's @CVanGuyen. That's @ CVANGEYN, and I'll be live tweeting tomorrow. Tomorrow's a big day because we're making our submissions starting at 9:30, and I'm really looking forward to it. So thanks very much for following along. Don't forget to like and subscribe. And if you want to support our work, you can make a tax-deductible charitable donation at the ccf.ca/donate. I'm really excited. And I'm going to go have dinner now. If you guys have any recommendations of where I can get dinner in Ottawa, let me know. Although I'm in downtown and in this ghost city, there's no one apparently in the downtown ever, especially after 4:30, maybe even earlier. I don't know. That's when I got out of court. Tomorrow we'll be in court 9:30 sharp. We get out at 4:30. So it takes me a little bit of time, maybe an hour or so, to compile my notes. So tomorrow I should be doing this live stream again at around 6 or 7, depending on how quickly I compile my notes. Okay, thank you all very much for subscribing and tuning in. Have a great night, everyone. And I hope if you watch tomorrow, leave a comment in the video to let me know what you thought of observing. Okay, good night, everyone.